Good evening and welcome to Lawyers on the Line. I'm Eric Beyer, a partner at the Duluth law firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and this evening's moderator. Tonight's topic is family law. Marriage dissolution is the most common legal proceeding in the United States, affecting at least half of all married adults. Disputes in marriage dissolution include division of assets, property, money, as well as custody and visitation with children. Sometimes custody and child support issues arise even when there's been no dissolution. Now, I'm pleased to announce tonight's panelists, Bill Thompson of Bill L. Thompson Law Office here in Duluth, Nora Sandstead of the Hampton-Freedy Law Firm here in Duluth. Please call us with your family law questions for Bill and Nora at 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. Bill, why don't we start out talking a little bit about what is family law generally? What kind of issues do you face?
Well, family law covers a large number of topics. The two primary issues are obviously dissolution of marriage or divorce. Custody, given the number of children born out of wedlock, is obviously another one. Parenting time goes along with the custody issues, but it can also include things like orders for protection, harassment restraining orders, adoptions, grandparent rights, child support issues. It really encompasses anything that really potentially could involve a family.
Okay. Well, let's go right to some questions that we've got to start out with. And Nora, a question from a caller is, at what age can a child pick who they will live with or who they want to see? Or at what age does a child have a say in a court proceeding about visitation or parenting time or who they want to live with?
Well, to some extent it depends on the child, but in general, a judge is going to be open to the input of a child, not directly in the courtroom, but through a guardian ad litem or through parents or through a therapist. As the child gets older, they're going to give more weight to a child who's 14 or 15 than an 8 or 9-year-old.
Okay, if a young child has a strong preference, whether or not that's rational, of course, is obviously up for debate, but do they have an opportunity to speak about their preferences in court in a typical case?
A young child is generally not going to be invited into court to speak.
Is there a bright line about what age that becomes, they become allowed to do that? I mean, like driving, you can drive at 16. Is there something?
There is not a firm age. It's up to the discretion of the judges, but generally speaking, the judges prefer not to bring children into the courtroom because it's quite an experience, and so they'd rather keep the children in a safe environment and allow them to speak through representatives.
Okay.
It really is one of the biggest myths in family law that there's a magic age around 12, 13 where a child just gets to pick where they want to live or what schedule they're going to see the other parent. And really that doesn't happen until the child turns 18 when they legally become an adult. As Nora was saying, the older and really the more mature the child gets, the more weight it will give. But the law clearly states that the court can't give preference to one best interest factor over another.
Well, what does the court consider when they're when the court is making determinations about where a child will reside? Nora?
In terms of a child's primary residence, that will go to the question of their physical custody, and the court generally starts with the best interest factors, and there's a set of factors determined by Minnesota law, and they include who has been the child's primary caretaker, the child's current community where they reside, how long they've lived there, their education, any concerns involving domestic abuse in the home. Help me out, Bill, what am I missing here?
The permanency and stability of a household, you know, how long has that family unit been in place? I don't know if you mentioned whether domestic violence occurred. Mm-hmm. Then if there's joint custody that's potentially in play where the parents are going to share legal or physical custody, there's a number of other set factors that primarily relate to how well the two parents get along.
Could you talk about custody? A lot of times with, just from a layman's standpoint, we understand somebody may be the sole physical custodian of a child. What are the different types of custody arrangements?
Well, in Minnesota, there's two different types of custody. One is legal custody, and that involves the say in the major life decisions facing a child. Religion being one of them, medical decisions being the other, or medical and school being the three primary issues that legal custody involves. And really, there's a presumption in Minnesota that joint legal custody will be what occurs, because obviously they want both parents being involved in the major life decisions facing a child, where they're going to school, whether they're getting proper medical treatment. Then there's physical custody. In Minnesota at this point in time, the presumption is against joint physical custody, but physical custody entails who has the say in the normal day-to-day interactions of the child.
Okay. Is joint custody common? How often does that come up where you have joint physical custody?
Joint physical custody, because there's a presumption against it in Minnesota at this point, it's not as common.
And that would be where the children actually go between both houses, right?
To some extent. Okay. Custody is a label. Physical custody is a label, but then also the court will look and decide parenting time, or the parties will agree. And so even if one parent has sole physical custody, often the other parent is having some parenting time, even up to half parenting time. And so generally speaking, the physical custody label will match kind of who has more time with the child, okay. But there will be a separate parenting time schedule, and that will really determine how much time the child spends with either parent.
I imagine we'll probably get a child support question coming up, but we did get a call that just came in. It says, if my daughter's been married for 3/4 of a year and she left because of abuse and then changed the locks on her house, is that legal? I take it basically she was worried about her own safety and said she didn't want to let him back in the house. Can somebody do that without any repercussions? Or?
Well, obviously when you're trying to protect your own safety,
right.
You're entitled to do certain things. Right. The other thing she could potentially do is go get an order for protection. Right. If she can show the allegations that there's physical harm or imminent threat of physical harm, one of the things you can do in an order for protection is address who gets temporary residency of the homestead. Technically, if you're married, both have joint occupancy of the home until a court says differently. But under certain circumstances, especially in a case involving domestic violence, I don't think anyone's going to get too bent out of shape if she changed the locks.
Okay. All right. So order for protection is probably the best way to go if you're fearing for your safety, I would assume.
Correct. Well, and if it's immediate safety, 911.
Right. Good advice, Bill. Nora, a call came in. A couple has a pending divorce. If they have children, do they have to go to court to get that marriage dissolved?
If they have children, if they're both represented by attorneys, they won't necessarily have to have a court appearance. Is that correct?
That's
Bill?
correct.
Yeah. If only one of them is represented by an attorney, they will both have to appear in court, or if neither of them are represented by attorneys, then they will have to appear in court.
Okay. And of course, if they have everything sorted out ahead of time, then they probably wouldn't have to have as much time in court. Is that right? I mean, can people draft paperwork without an attorney?
Yeah, I mean, there's always an option, especially in simple divorces where there's not a lot of assets, or if the parties are in agreement to custody and parenting time, you can always go on the Minnesota Judicial website. There's a link for court forms, or you can go to the courthouse. There's all kinds of fill-in-the-blank paperwork for family law issues so that people can do it on their own if they so choose.
Okay, but if one's represented, they still have to get that final paperwork approved by a judge?
That's correct.
Okay. Yes, if there's a child involved.
Okay.
Another helpful website is the Law Help MN website, lawhelpmn.org. Has a lot of resources, especially for family law.
Okay. This is a financial question coming from Duluth. It says, if a couple is wanting to get a divorce and the husband's income is military disability, not Social Security, is that protected, or will the spouse be able to get entitled to half of that? Now, why don't we talk, first of all, the difference between splitting income or sharing income and splitting property, because I think that might address this question to some degree. What's the difference in terms of splitting assets in a what's considered an asset that's divided in a divorce?
Well, an asset or a liability is something that was accumulated during the marriage. I mean, the most common asset that most families have is either their retirement income or retirement accounts, 401ks especially, or their home. Those are two assets that are generally accumulated during a marriage. Then you obviously have all of the debts. As far as income is concerned, obviously it's when you're employed. In this particular case, it's a military disability, which is different than a military retirement. Disability would generally not be divisible in a marriage. It's not assignable to anybody else. What it would be is potentially considered to be an income stream if the issue of maintenance was in play or child support.
Okay. Nora, why don't you talk about what is maintenance? I think it used to be, well, I know it used to be called alimony, and that term's not used anymore, true?
Correct. Under Minnesota law, now spousal maintenance is the term that is used, and that can be awarded to a spouse who doesn't have the income on their own or the ability to gain the income on their own to match the standard of living that was established during the marriage. And it depends. A court looking at spousal maintenance is going to look at each party's earnings and compare them and see if the party who needs money, how much they need, and the party who makes more money, whether or not they can afford to pay it.
Okay.
And it's a question that the judges are given broad discretion in.
Okay, well, getting back to this call then, it doesn't sound like that's something that would be necessarily divisible. The military disability, that's an income stream for the person who was awarded that through their military service and ultimate disability, right?
Correct.
So that would be divisible only if the other, or that would, he might have to pay some of that to her if she doesn't have any income and that was their sole source of income, theoretically.
That's correct. But
how likely is that in this case?
It's hard to say. I mean, because with spousal maintenance, not the global scale, as Nora pointed out, it's the need of one party to receive it and the ability of the other party to pay it. Well, in almost the vast majority of divorce cases, given the economy where it's at in the job market, there's almost always a need. The question's always the ability for the other person to pay it. But spousal maintenance goes well beyond that. There's a number of specific factors that the court has to look at to award spousal maintenance. The length of the marriage, lack of earning capacity, length of time outside the job market, what it would take to be retrained and enter back into the job market. Those types of things all have to be considered when addressing the issue of maintenance as well. And unlike child support, where you plug in both parties' income and out pops a number, maintenance is completely all over the map. And you could ask 10 different judges the same fact scenario, and you might get 10 different amounts, 10 different durations. There's no rhyme nor reason behind maintenance.
Okay, all right. Nora, a question we have here. If I have sole physical custody, can I move out of state with our child?
Not without the court's permission,
Okay.
if there's another parent involved. Just having sole physical custody doesn't allow you the power to move out of the state if there's another parent who has visiting time.
Okay. Bill, why don't you talk about visiting time, I think, or parenting time. What exactly is that and what factors are involved in terms of trying to determine how much time a child spends with a spouse or one of the parents that is not the physical custodian?
Well, there's a presumption that the non-custodial parent is going to have parenting time. As far as how much parenting time, it's really based on the same 13 best interest factors that the court would consider for custody as well. And really what the courts try and look at is, if the parties haven't been together, what have they been doing? I mean, the courts are huge fans of stability and continuing what parties have been doing. But they also try and look at what are parties' work schedules, what's the child's schedule, what schedule really fits into the needs of both parents. But they want to ensure that both parents have an active role in the child's life, both parents have an access to the child, and then obviously depending upon the age of the child, the schedule can change as well. Usually there's, less overnights when you have an extremely young child. Those overnights then gradually expand as the children get older.
Okay. Nora, I've got a question here. It says, My fiance cheated on me and broke off our engagement. I get to keep the ring, right?
So Minnesota law is very clear on engagement rings now. No matter who's at fault and who did the wrong, if the marriage does not happen, the ring goes back to the individual who purchased the ring.
Really? Huh.
It's a conditional gift, and the condition is the marriage.
Sure.
And if that condition doesn't happen, then the gift has to go back.
Now, this kind of gets into an old question that we used to get all the time about common law marriages. Does that exist, first of all?
Not in Minnesota.
Okay. What changed then, if it's not through the courts or the common law process? What changed? Was this actually a statutory change that happened about the engagement ring?
There was a court case
Oh,
that
really?
decided
Okay.
how to interpret this.
Oh, wow, okay. Next question. My wife just moved in with her boyfriend, the one she happened to have left me for. Do I get to stop paying maintenance now?
No. It only happens upon remarriage, not necessarily. There are sometimes cases where people have been together long enough as boyfriend and girlfriend. At least in Wisconsin, there's some case law on that, but generally it's death or remarriage, or if there's always a substantial change in financial circumstance, maintenance can be modified as well.
Okay. Nora, question we've got here from Duluth. I want to get divorced, but I don't have any money. What should I do?
Well, we talked earlier about some resources online that you can access through the court's website or through Minnesota Law Help. There are also some resources in the area through legal aid and the volunteer attorney program that can provide some free advice. So certainly folks can try to initiate their own divorce, and there's a lot of paperwork to be filled out, but it's put forth in a pretty simplified form.
Okay.
And if you have questions on that paperwork, I think it's every Wednesday now at the courthouse, there's the Ask an Attorney program sponsored by the Volunteer Attorney Program.
Right. We'll give that number out at the end of the show tonight, actually.
Okay.
A question from Cloquet. What does a man need to do at a baby's birth to declare paternity of a child if the couple is not married? Let's talk about paternity.
Okay. Well, paternity can be done in a number of different ways. One is at the time of the hospital, there's the option, if both parents choose to undertake it, is to sign what's called the Minnesota Voluntary Recognition of Parentage. And it's a document that both parents sign and execute that indicates they're in agreement that this child is mine. It is then binding upon the parents themselves if they choose, and they only have so long to change their mind. If they don't, they're now locked in, and you can't, 3 years later say, I want a paternity test now because I don't believe the child's mine. The other option is to go through the court system to have paternity established, request genetic testing, and actually know for certain that the child is yours. If you don't sign a recognition of parentage, there's always the possibility that the county will then file the paternity action if public assistance is being paid. And then there, on a routine basis, the child support magistrate especially is always asking for genetic testing just so they don't have to worry about the issue of questions of paternity down the road.
Okay.
And if the parties are not communicating, a potential father who thinks that there may be a child can register with the state father's adoption registry search. And that group through the Minnesota Department of Health would notify the father if the mother put the child up for adoption.
And then there's one other thing to remember too, for fathers especially, or mothers for that matter. Just signing the voluntary recognition of parentage does not give you any legal rights to custody or visitation. It allows you to skip the paternity process and ask the court for rights of custody and visitation, but until there's a court order, mom has sole physical and legal custody if the child is born out of wedlock.
Okay. Call from Saginaw. Basic requirements for getting a child, a temporary custody of a child if the parents are not married. So let's say that we establish that or we establish paternity. What does a couple have to do in order to establish a temporary custody situation?
Well, as Bill just said, the mother automatically has sole physical and legal custody under Minnesota law, and so the father would need to bring an action for custody and request file a motion for a temporary hearing in order to get a judge to establish a temporary parenting time schedule and some temporary custody, a temporary custody decision. Or if the parents are in agreement, they can present that to the court either in writing or in person and have that ordered.
Okay. And forms for people that don't have attorneys are available at the courthouse to do some of this, I understand?
Yes, there's parenting time assistance, there's the documents for custody for children out of wedlock, there's the dissolution paperwork, child support, just about every family law action that you can think of other than adoption and grandparent rights, there's usually a form for.
Well, interesting you talk about grandparent rights. We just had a call in that said there's a protective order against dad of the kids, but the kids stay with the grandparents sometimes. Do the grandparents need to get a separate order of protection so dad can't step foot on their property? And then what kind of evidence would they need to prove up an order for protection if they felt they needed that? And take anybody?
Well, in order for protection, you always have to be able to show physical harm or imminent threat of physical harm. If you can't establish those two, you can't get an order for protection. If there's already an existing order for protection that says dad can't have contact, whether it was mom that brought it or not, I'm assuming that that would still potentially give them at least some protection, because if he has contact with the children, he's still violated an existing order for protection.
The order for protection usually addresses visitation and parenting time, I assume?
Yes.
Okay.
If there's children involved, usually the court almost always will address it in one way, shape, or form, because usually that's one of the main issues that's being dealt with. Obviously, you can have relationships where there aren't children involved, but in many of the ones that are seen by the court, there are minor children.
Not to get too hung up on this one, but I guess this caller's question is, what can I mean, maybe it goes to just a simple trespass action. I mean, if somebody doesn't have permission to be on your property and they have no legal right to do that, I suppose you call the police.
Well, sure. I mean, a lot of what happens with an order for protection potentially triggers other criminal law as well. I mean, if I threaten to kill you, obviously you could get an order for protection because that potentially would create a threat of imminent harm, but it also might be a terroristic threat. You know, I mean, there's always the possibility of dialing 911, and even if you get an order for protection, to enforce it, you still have to call 911 as well.
All right. Call from Duluth. After settlement agreement, can you go back and look at the settlement agreement if a party comes into a pension or receives Social Security or additional income? How do you modify a marital termination agreement, I guess?
Well, if the termination agreement has already been ordered, then you're looking at a post-dissolution modification, and it would depend on how the person is coming into the money. If it's something that they earned during the marriage that is just sort of being discovered after the marriage, then it's still marital property that can be divided. If it's something that they've earned after the marriage, then it's their non-marital property.
Okay. I guess since you're using the term marital settlement agreement, I'm wondering if it hasn't gone to judgment, but if once you sign a marital settlement agreement, it's considered a binding contract on both parties, and you need to vacate it pretty much on the same that you would need to vacate an existing order of dissolution, which is you need to show some type of fraud so that they didn't disclose the pension information or whatever source of income it was at the time you actually entered into the agreement.
Okay. Just got a call. I'm not sure it relates to a disputed medical charge. Maybe let's just assume that it means a woman called in. She's not happy with her attorney. That might be superfluous, I guess, for our discussion. But they want to dispute medical charges. Let's say that they have a debt that they don't think they should be responsible for. How does one argue that, or what type of evidence would somebody need to say that, look, I'm not responsible for this type of charge?
Well, usually you would need the same thing, well, as you would imagine. If it's a debt, you need to be able to show that it was somehow not related to the marriage. And the example I always give is, husband has a $20,000 credit card bill. You get a copy of the statement and you show that $10,000 of that was his trip that he took to Florida with his girlfriend. Most courts aren't going to order you to pay half of his trip with his girlfriend. But usually that's a pretty easy one, and you don't see it very often. Most things, debts especially, are accumulated during the marriage and during the normal course of expenses that you would expect during a marriage.
And the rule is generally if it's accumulated during the marriage, no matter who incurred it, as long as it's not some sort of fraudulent type thing, it's each spouse's debt jointly, is that right? Or they separated jointly?
Right.
Correct.
Okay.
And that includes medical debt.
Okay, all right. Nora, probably our last question. Take us through quickly this question. I just got remarried and would like my husband to adopt my 10-year-old. What's the process? Generally, what's the process in adoption?
So a step-parent adoption is it's not too complicated, but first the child has to be available to be adopted. Okay. In Minnesota, you can only have 2 legal parents. And so if there's another parent who has parenting time or some involvement, then that parent is going to have to give their consent or have their rights terminated based on abandonment or neglect.
Okay. We're gonna have to wrap it up there.
Okay.
Time flies. That's all the time we have tonight. But we wanted to let you know that that you can have your questions on tonight's topic or any legal topic answered every Wednesday at noon, as Bill said, at the St. Louis County Courthouse through the Volunteer Attorney Program. Ask an Attorney Service. Call 723-4005 to make an appointment. You'll get 10 to 15 minutes one-on-one with a local volunteer lawyer who will be able to answer questions and lead you to the right path to find additional legal help you may need. This program is free and available to the public regardless of need. Remember, you can watch tonight's program again online at wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we answer your questions about premises liability claims. I'd like to thank our panelists for their expertise this evening, and thank you for watching. I'm Eric Beyer. Good night.